Great, long overdue news for fast food workers in New York City. The City of New York recently passed a law requiring just cause protections for fast food workers in New York City. The New York City Council passed this legislation in December 2020, granting fast food workers union-like contract protections, entirely eliminating traditional at-will employment rules. So starting in July 2021, when the law takes effect, if you work at a major fast food restaurant chain with at least 30 locations in the US, which is most of them, and you work in New York City for one of them, you can no longer be fired for any old reason or for no reason at all anytime your boss feels like it. This new 2021 law requires that all terminations from employment at fast food restaurants be for legitimate, just cause, which I'll explain in a moment, or for so-called bona fide economic reasons, and it's on the employer to prove it. Additionally, this new law requires that these fast food restaurants engage in what is known as progressive discipline, which means that before you're allowed to be fired, the employer must try various levels of warnings and write-ups, verbal and written, depending on the alleged infraction seriousness, etc., before an employee can be terminated. And these write-ups, each of these write-ups must sunset or expire and disappear entirely from the employee's record after 1 year. Finally, this new law allows discharged employees to take their case free of charge to arbitration, like again in a union type of contract setting, through a New York City created panel, or the city can bring these claims to trial at New York City's Office of Administrative Trials and Hearings, an agency known as OATH, also at no charge to the employee. So-called just cause is defined in this new law as egregious misconduct or some serious performance issue. So the bottom line is that you have to be accused of something really bad for a firing to be considered legitimate, not just because you rubbed your manager the wrong way or you made one little mistake. For example, did the employee know that a policy was being violated? Was there adequate training? Did the employer use reasonable progressive discipline? Was there a fair objective investigation? And did the employee actually violate the employer's policy or rule? This new groundbreaking New York City law also limits when an employer may lay off an employee or reduce her hours to only situations when legitimate bad economic circumstances exist, which is defined as the full or partial closing of operations or other changes in response to a substantial reduction in business. Layoffs must be done in reverse order of seniority, and recently laid off workers must be permitted to work again to get these hours before currently working employees can get those hours. The employer must also give any discharged employee a written explanation with the precise reasons for the firing within 5 days of the employee's termination. Now, there is a 30-day probationary period when all new employees can be discharged for any old non-discriminatory reason, but after that 30-day period, the new protections kick in. And even before July 2021, if you believe that you or a loved one is being treated differently in the workplace due to discrimination, harassment, or retaliation, please feel free to contact this law firm for a no-charge consultation. This is Jack Tuckner, a New York-based employee rights lawyer. Please give a like to this video if you would, and please subscribe to this YouTube channel for the latest employee rights news delivered directly to your inbox, hot off the press. Stay safe and be well, and thank you for listening.